Hello, ladies and gentlemen. My name is Lowell Walters, and I want to talk to you about two new pieces of IRS guidance that may lead to some more or better engagement or appreciation of your employee benefits from your employees. Now, I am an attorney at Carlton Fields, and the focus of my practice is employee benefits. Employee benefits or employee benefit issues can arise anytime you are providing employees something of value other than direct cash compensation. So, engagement, or what we call engagement, is really very important. I hear it talked about a lot at 401k committee meetings. And the idea is that engaged employees are more likely to use your employee benefit plans for their intended purposes. For example, they are more likely to use your retirement plan to save for their retirement. If you have a dependent care assistance program, they're more likely to utilize that to help make childcare more affordable. Um, your benefit plans are more likely to pass non-discrimination testing with engaged employees because they are more likely to use those benefits, particularly non-highly compensated employees or individuals who are more likely to use those benefits. And your employees will appreciate your benefits more, making your employee benefit plans a better retention tool. So the first piece of IRS guidance is IRS Notice 2024-63, issued earlier this year about employers making matching contributions and including the amount employees pay towards loan repayments in those matching contributions. So this can be used by employers that have employees making salary deferrals into 401k plans, 403b plans, governmental 457b plans, and even simple IRAs. This would not apply to employers who only allow employees to salary defer into a non-governmental 457b plan. It would not apply to those. So on any of those arrangements, right, if you as the organization or the employer makes a matching contribution based on employee salary deferrals, employees with loans can sometimes be hit with a double whammy. If they're not able to put as much into the retirement plan as they would want because a portion of their disposable income is going towards the repayment of loans, not only are they missing out on making all of the salary deferrals they would like, but then they also might be missing out on some of the matching contribution. So this can really help that group of employees. And if you're looking to attract employees that have recently completed their education or have student loans, this can be an additional retention tool for those kinds of employees. In essence, you'd look at how much they put into the retirement plan and how much they pay towards loans, and you would base your matching contribution, up to your maximum threshold on those two amounts. So potentially very attractive to students coming out of school with student loan debt. If you are an organization that is having trouble passing testing on your match, this might be a good option for you. The IRS guidance does provide information on how this will impact testing. I'm not going to detail that, but if you are barely passing testing or you generally come close to or fail testing, this might be an option worth considering. Another benefit from the IRS guidance is you as the employer don't need to do a lot of work in finding out information about the loan. Most of what the IRS wants you to get or wants you to know, you can get it through an employee certification. Now, one important factor that I noticed in this guidance that may be a key consideration for you is that when you look at your employees' loan repayments, they may not be loan repayments just for the employee's education. All right. If those repayments are for the employee's education or the employee's spouse or the employee's dependents, i.e., children, they would also need to be considered for the matching contributions if you rolled out this option. All right. So now this might make it even more attractive for some of your longer term employees that have been with you a while. Maybe now their children are going to school, or maybe their spouse, maybe the children have finished school. Now the spouse is going back to school. So this can be even more of a retention tool for those employees. However, if you heard this and your thinking is, wait a minute, I'm all for education and we're comfortable providing money to help our employees educate themselves because that makes our employees more valuable to us. But you don't like the idea of making a match based on loan repayments the employee is making for their children. That is not a restriction this guidance would allow you to make. So if that was your thinking, you might want to consider using an education assistance program instead. An education assistance program is an arrangement where you will make money available to employees for the employee's education. And you can control the type of education it is, the schools they go to, the classes they take, et cetera. You can exercise a lot of control with an education assistance program. With this arrangement on matching contributions going into retirement plans, you cannot exercise as much control over that. Now, the other piece of guidance that was issued earlier this year is a private letter ruling that allows employees to make an election during your cafeteria plan open enrollment to say, if my employer makes an employer contribution, I don't want it all to go into their retirement plan. Instead, I want some portion to go into the retirement plan, and I want the rest or other portions to go towards another employee benefit plan. In this guidance, the IRS was permitting redirection into cafeteria plan benefits, and this might sound similar to in your general cafeteria plan, right? Right now, your general cafeteria plans during open enrollment, the employee might say, okay, I'm directing some money towards health insurance, some money towards dental. They may say, I know I can direct money towards vision insurance, but I'm not going to. Instead, I'll direct some money towards a health FSA or a decap FSA. And although it's not popular, you are permitted to let employees make salary deferrals into the 401k plan during open enrollment. So this kind of just takes that portion that you might say and expand upon it to allow the employer money to head in there. Now, if you've been working with cafeteria plans for a while, you may be familiar with the concept of flex credits or cafeteria plan credits. This was a situation where the employer, instead of saying we're allocating this much money towards your health insurance, it would say, here's a massive money that we're willing to put towards your welfare benefits in general. You allocate it where you want among your welfare benefits. So what's going on here is more similar to that, but with the retirement plan contribution, right? The employee can now say, some will go into the retirement plan and others will go into the cafeteria plan or different benefits. Now, keep in mind, what the guidance did say is that amounts going into the retirement plan will be valid retirement plan contributions. Amounts going towards health insurance will be valid employer contributions towards health insurance, et cetera. So the key seems to be that these amounts are retaining their character as employer money. Other than that, though, it did not go into how it affects non-discrimination testing. That, of course, is a very important part of all this. And my expectation, right, just expectation, is that amounts that get directed into the retirement plan are valid retirement plan contributions. Amounts that go towards health insurance are considered employer contributions towards health insurance, and they are not counted for retirement plan purposes. And it would go down the line like that. If so, you could imagine that if you don't have a safe harbor plan and it's a lot of your non-highly compensated employees redirecting amounts towards health insurance benefits, it actually could hurt you when it comes to non-discrimination testing. Mm-hmm. So let's see. So that is one thing to keep in mind. Another item to keep in mind is that this is a private letter ruling. All right. And when the IRS issues guidance, there's different tiers. Like a regulation is a big deal. The IRS is going to stand by that. maybe revenue procedures, right? IRS notice. And as you go down the line, private letter rulings, they're relatively low down on the list. If you paid to get this ruling, if you were one of those, the taxpayer who paid for this ruling, asked the IRS this question and paid for them to answer it, actually, then you are able to rely on it. For the rest of us, this is indicative of how the IRS would look at this situation at this point in time. But if the IRS has a change in position, they do not need to issue new guidance. They do not need to say, hey, we're changing our position on this private letter ruling. And we're going to give you a year to bring your arrangements into compliance. They don't have to do that for private letter rulings. So keep that in mind as well. So anyway, those are the two items I want to talk to you about today. Two things that optionally, they're not mandatory, optionally you can incorporate into your retirement plans if you think it would improve your employee engagement, if you think it would be right for your organization. Certainly, if that's the case, I would encourage you to speak with your benefits advisor or to contact me. And if you have any questions, you can email me at lwalters@carltonfields.com. Thank you very much.